can request secure access, exchange, and use of electronic protected health information via smartphone applications or computer software. And they can make these requests pursuant to the Cures Act without any delays and without any restrictions. So it's really a groundbreaking piece of legislation, which is really expanding the ability to utilize electronic health information, not only by patients, but also among healthcare providers. What's going into effect on April 5th is what's referred to as the final rule. So Congress passes the Cures Act back in 2016, and then it's designated to the Department of Health and Human Services to come up with the implementation of what was contained in the legislation. This was delegated to the Office of the National Coordinator for Health Information and Technology, or ONC as it's referred to, and they've developed what has become their final rule. This is actually what must be followed. It's their recommendations of what needs to be done, and that's what's taking effect on Monday. It applies to the interoperability of electronic health records between providers, and also it has developed the rules concerning information blocking, as well as exceptions to the rule of information blocking prevention. So let's just talk briefly about what is information blocking. Pursuant to the Cures Act, information blocking means any practice, except that that's required by law or covered by one of the exceptions that we'll talk about, that is likely to interfere with the access, exchange, or use of EHI. If this blocking is being conducted by a health IT developer, a health information network, or exchange, it's implied that they know or should know that their practices are likely going to interfere with access and exchange or use of EHI. If it's conducted by a healthcare provider, it's going to be blocking where that healthcare provider knows that the practice is unreasonable and likely to interfere with the access and exchange of EHI. We'll talk about that later on, because that's a very important distinction. So what are some examples of information blocking? In the context of patients, it can be something as simple as restrictions on when they may be able to access their electronic health information. So for example, if you have laboratory results on your electronic health record and you have a policy in place that they must be reviewed before a patient can access them, that's potentially information blocking. Also, limitations on the scope of electronic health information that they may access. If they can only access limited portions of their chart, let's say they can access laboratory results, or they can access other diagnostic testing, but not your progress notes, then that would be a limitation on EHI. Any unnecessary delays relative to requests for access to this information will be considered blocking. And also patients that are locked in to a particular technology because their health network is not portable. They can't transfer that information, so they're forced into using the same providers that are contracted with their health network. These would all be examples of patient information blocking. It's not limited to patients. Information blocking also happens among healthcare providers. So for example, if a provider encounters an inability to access electronic health information from another provider, that would be information blocking. If a hospital or system has a policy in place that a provider has to obtain written consent before sharing information with another provider, that would be another example of blocking. And also in the context of contractual agreements or business associate agreements with vendors concerning how there may be limitations on how EHI can be accessed, exchanged, or used. For example, if you're changing vendors for electronic health records in your office, and the prior vendor may have some sort of limitation on the information that they have gained access to, that would be an example of information blocking. So what makes an individual or an entity an information blocker? There are a number of elements that have to be satisfied. First, the person has to be an actor that's as defined under the provisions. It has to involve electronic health information, and the practice that they're engaging in is likely to interfere with the access, exchange, or use of EHI. And as I alluded to earlier, the actor must have the requisite knowledge of what they're doing is actually an interference. And finally, their acts that are blocking information cannot be something that's covered by law or falling into one of the exceptions for information blocking, which we'll talk about later on. First, the actors that are regulated by ONC concerning information blocking. Obviously, healthcare providers, all physicians, any practitioners, physician assistants. I mean, they would all fall into that category of a healthcare provider. Health IT developers. So again, any vendor that develops IT software, they are going to be considered an actor. And then finally, health information exchanges and networks. You know, these are the how information is transferred from one provider to another or accessed by payers. They would all also fall into the definition of an actor. What is electronic health information? Well, the Cures Act defines EHI as basically EPHI, which is protected health information, electronic protected health information under HIPAA. So what does that mean for a practitioner? It's your designated record set for a patient. So it's going to be the patient notes, billing records, laboratory results, diagnostic tests, whatever's contained in that in your electronic health record, that's going to be considered electronic protected health information. Similar to HIPAA, this excludes psychotherapy notes and would also exclude any personal notes and observations you may generate that you have contained in your EHI. That's not something that you'd be required to provide in response to a request. I would note that between the dates of April 5th, 2021 and October 6th, 2022, the definition that's going to be utilized will be the minimum data elements under the United States core data for interoperability. That's really just a complicated way of saying that the records that need to be provided in response have to comply with that standard as opposed to the HIPAA standard. The reason for this is it's giving these IT developers time to complete developments that they have made concerning their records retention, their definition of records and elements. So as far as healthcare providers, I don't see any real distinction. The components contained in the US CDI are synonymous with what's contained in the HIPAA definition. So again, it's patient records, your notes, your billing, the usual materials that you maintain and will provide in response to a request. I spoke earlier about the knowledge standard distinction between the actors, and this is very important if there is ever an investigation after a complaint of information blocking. So as you may have seen, health IT developers, networks, and exchanges, they can engage in information blocking where they know or should know that their conduct is going to interfere with EHI access, exchange, or use. Whereas the definition for a healthcare provider is he or she's going to engage in information blocking where they know that their conduct is unreasonable and likely to interfere with the EHI access. So that's an important distinction. Their definition for information blocking for a healthcare provider has a consciousness component to it. They have to be aware of what they're doing, and they have to know that it's unreasonable behavior that's going to interfere with blocking. I think that element would be very difficult to establish if there is an investigation. So that's very important for healthcare providers as opposed to the IT developers and the networks. So what are the exceptions where information blocking is still permitted? First of all, by reading the definition of information blocking, we know that compliance with state and federal laws is still acceptable. So for example, if there's special areas of confidentiality, such as mental health records, HIV treatment, drug and alcohol treatment, again, there's heightened requirements for the release of that information regarding patient consent. So if you did not provide that information in response to a request, you would still be you're acting, your behavior is information blocking, but again, you're still in compliance with federal HIPAA regulations and New York State privacy laws. So that would not constitute information blocking. In addition to compliance with laws, the ONC in its final rule outlined 8 exceptions that will not be considered information blocking. I'm an attorney, and I believe it or not, I love reading these statutes. But I got to tell you, these particular statutes are really it's a lot to digest. So I'm not going to go through all the specifics. I'm just going to talk briefly about the exceptions and some of the preconditions that are required. To satisfy each of these exceptions, the actor must successfully meet all the preconditions per each exception. that will automatically entitle them to immunity from information blocking. But the rules do say that partial compliance is not going to be an automatic finding of information blocking. ONC and the Office of the Inspector General, who's really the one that's carrying out the enforcement of these regulations, will perform their analysis on a case-by-case basis. So what are the 8 exceptions? They're really broken down into 2 categories. The first is exceptions for not fulfilling requests to access or exchange or use of information. And these are exceptions for preventing harm, privacy, security, infeasibility, and health IT performance. The other category is exceptions for procedures for fulfilling requests to access, exchange, or use EHI. And again, these are sort of focused more so, I think, on the IT vendors. And these are exceptions for content and manner of the response, fees. That could also apply to providers charging fees relative to the release of the information. And finally, licensing exceptions. And again, that one in particular is going to be geared towards the IT developers. So let's talk briefly about the preventing harm exception. Give me 1 second here. Okay. So by definition, it will not be information blocking for an actor to engage in practices that are reasonable and necessary to prevent harm to a patient or another person. So under this exception, there are a number of conditions that have to be met, but the most important ones are that the actor's belief must be reasonable and that it has to substantially reduce the risk of harm. It's also an important requirement that the blocked information can be no broader than necessary. There's a theme throughout all these exceptions of really limiting the information that's being withheld and making sure that it's done on a consistent basis without any discrimination. That's something that we'll see in all of these exceptions. The second exception for information blocking is the privacy exception. Information blocking will not occur if an actor does not fulfill a request for access, exchange, or use of EHI to protect an individual's privacy. So again, the HIPAA regulations, New York state law requirements for written authorization before a medical record is released to a third party, that would still be enforceable, and you would have to comply with that before releasing any information. So that's an example of the privacy exception. Security exception. There will not be information blocking where it's done to protect the security of the EHI. So if the information blocking, it has to be directly related to safeguarding the confidentiality. And again, it has to be consistent and non-discriminatory. So again, any restrictions that you would have in place from a security standpoint, IT purposes, preventing exposures or breaches. But again, it has to be consistent and carried out non-discriminatory. The feasibility exception. And the actor does not have the technological capabilities or the legal rights to respond to the request for access. So there are a number of conditions that would qualify for this exception. The first is uncontrollable events. So for example, if you encounter a disaster, you encounter a public emergency, or even perhaps a cyber attack on your system, and you're not able to respond to a request, that would be an example of the feasibility exception. Segmentation. If you receive a request for records or access to information and it's limited and there's only certain information that could be provided. For example, there's HIV information in there, or there's drug and alcohol information in there, and you can't segment it. You can't provide only that limited record set based upon your technology, then that would be an example of the infeasibility exception. And then finally, it's just simply infeasible under the circumstances. Perhaps the request that came in is just not compliant in some way with your technology capabilities, and you just cannot meet the response that is being demanded. These are all examples where it's infeasible. But again, it's important to note that if you are unable to respond due to one of these measures, you must provide a written response to the requesting individual within 10 days of their request for access, exchange, or use. The remaining exceptions really are, again, well, not actually, this one's not, the following one would be, but the health IT performance is another exception that would be applicable, I think, extensively to providers and systems. And again, if you have to take your system offline to undertake reasonable and necessary measures to ensure the security of your system, that's permissible, and it would not be information blocking. Again, the measures must be implemented for a limited time, no longer than necessary. And again, the measures have to be consistent and non-discriminatory. The content and manner exception, again, this one here is more focused on the IT developers. It will not be information blocking if the response in response to a request is the manner in which it's done, it can't be met. So for example, I was talking about the distinction between the definition of VHI by HIPAA and the US CDI. That would be an example of a content issue that would not be able to comply with a particular request. And then there may be a manner issue that's associated with the request, and it's just technically you're unable to fulfill the request, based upon the way it's being submitted. For this exception to apply, you have to meet both of these components, both the content and the manner. And if you can't fulfill the request in the manner that's requested, it's still required that the actor provides a response in an alternative manner. So you may not be able to get the requesting person the information how they wanted it or what they wanted, but you still have to provide a response in an alternative manner in order to be compliant. Fees exception. An actor can charge fees for the release and access and use of the information, and can even result in a reasonable profit margin. Again, the goal here of the Cures Act and these information blocking and interoperability provisions is to really enhance the technology, and that there's costs associated with that. So it appears the government was cognizant of that when they were developing these exceptions and regulations, and that is an important one. So you can charge fees relative to the exchange and access of this information. However, they did stress that this is not supposed to be rent seeking. They're going to guard against any behavior such as that, or unnecessary fees or exorbitant fees that could potentially result in exclusionary practices. And the last exception, this is definitely geared towards the information technology developers, and that is licensing exceptions. It's not going to be considered information blocking for an actor to license the interoperability elements of their EHI software relative to access, exchange, or use. Again, there's a number of conditions that have to be met, and it has to address the scope of the rights, the royalties that may be associated, and again, the terms must be non-discriminatory. It's a constant theme throughout the process. Enforcement and penalties. I should certainly touch upon that. The enforcement of the Cures Act and the final rule on interoperability and information blocking is delegated to the Department of Health and Human Services Office of the Inspector General. They have not developed a final rule yet on what these penalties could be. So the enforcement's not going to be something that you're going to have to really ultimately be concerned with until they do issue a final rule. OIG has not issued a final rule regarding what the penalties could be for information blocking. With respect to health IT and networks and exchanges, the Act does state that they are subject to civil monetary penalties of up to $1 million per violation. And again, they did stress that there's a number of factors that need to be taken into account, such as the number of patients that are impacted, the number of providers that are impacted, as well as how long the blocking was in place for. As for providers, they did not say that they are subject to the monetary penalties of up to $1 million. The penalties for healthcare providers are appropriate disincentives, and the appropriate disincentives were not defined in the Cures Act. It was not defined in the ONC final rule. And again, the Office of the Inspector General has not disseminated their final rule yet on these appropriate disincentives. Until these are in place, the OIG did indicate that they will investigate complaints, and use their discretion. So the fact that the rule is technically in effect on April 5th, I think practitioners have some time to get up to speed and get their electronic health records and information systems developed as we go forward. So let's talk about compliance with the final rule on information blocking. Again, the rule goes into effect on the 5th, but the clock is ticking. So you want to be proactive concerning your practice, your system, and it's really going to be a multifactorial approach. It's definitely going to require legal input. These are very complex, lengthy regulations with a lot of clauses to them that can become confusing. It's certainly going to involve your medical team and certainly your information technology staff or vendors that you utilize. A good starting place for compliance would certainly be the policies and procedures that you already have in place concerning the release of electronic health information. So that would be that. I would certainly start with a careful review of your HIPAA privacy and security policies. You want to see if there's anything that you have in place that could impede the ability to release information if a request came from a patient. Are there any policies in place that state that before a patient can have access to laboratory results, they must be released? Or, if that's something that you have in place, you may want to consider taking that out or changing it so perhaps fall within the harmful act exception. You want to make sure you consult with your IT staff or your vendors to make sure that you have the capabilities in place for this expansion of access that's coming. If patients are going to be using platforms, applications, and software to access your system, are you capable of handling that? Anytime you're expanding your digital footprint, you're expanding the surface area for an attack. Ransomware is very prevalent right now. We see a lot of that going on, not only with large health systems, but also with small practice groups. I've been contacted by physicians that tell me their EHR is frozen and they're getting a message that they have to pay $500 in Bitcoin or their information is going to be erased. So it's something to be aware of. If you are expanding your electronic services, you want to make sure that your system is up to date with any patches that need to be put on there for protection to prevent a chance for a cyber attack. And also consult with your electronic health record vendors that you have in place. What are they doing for compliance? Are they preparing for this? Are they adapting to the electronic health information definition? Or are they able to segment their record set to provide a response that excludes particular information that is not that is perhaps protected or restricted from disclosure? And you want to review all your existing contracts and business associate agreements that you have with vendors. Is the Cures Act implicated here? Is the information blocking provisions implicated? Meaning, are there provisions that are in place that put restrictions on information sharing which theoretically may be void now based upon the new regulation from the government? And again, as I mentioned, you want to, if you have policies and procedures in place that may fall within information blocking, perhaps they can be modified to fit them within one of the exceptions, whether it be for security, whether it be for harmful acts, or even for the privacy requirements. And finally, you want to make sure you educate your staff. They're really the first line of people on your team that's going to be encountering these requests for access and exchange of information. So you want to make sure that they are educated, they're aware of the changes that are coming, and what to do if they do get a request or even a complaint about access. So you want to make sure that they are your first line of your ears and eyes about these issues. So you want to make sure that they understand what's going on and what could potentially be coming down the road. So that's really all I have about the Cures Act for this evening. Again, this is it's brand new. It hasn't even been really implemented yet. It hasn't been implemented yet. So it's unprecedented with respect to the access and exchange and use of VHI. It's going to impact all patients and all healthcare actors. These are complex regulations, and it's going to require a multifaceted review of your existing policies and procedures and you're going to need to develop new policies and procedures to be compliant. So Again, thank you for your time. I really appreciate having the opportunity to talk about this. And again, don't delay. So you want to make sure that you are proactive. There are some resources available. ONC's website concerning the final rule is a wealth of information. They have an excellent frequently asked questions page that is constantly updated. A lot of good material there. And basically, the presentation that I've just given you is an article on the my firm's website. So if there's anything in here you would like to perhaps clarify or weren't too sure of, that would be contained in the article on the website. And if there's any questions or comments, I'd be happy to answer them at this time.
Great.
The question is on blocking. I don't quite understand the blocking. You can block certain parts of their record, or you can block the entire record, or you block everything. I don't understand that.
Okay. Information blocking is, they are entitled theoretically to their entire record as defined as electronic health information. There may be instances where there's a portion of the record that you are entitled to block. For example, as I mentioned, if there's anything in the record about drug or alcohol treatment, and they want you to release the records to a third party, if you don't have an authorization for that, you cannot release that information by law. So that's something that would be held back, and that sort of ties in with what I was saying about being able to segment the records that you're providing in response.
Thank you.
You're welcome.
We do have some
Question?
Go ahead.
Mr. Hassett, first of all, great talk. So thank you. I appreciate it. I have two questions. The first, which may be a little bit out of the scope of this, but where does the constitutional authority for this act come from?
Constitutional authority. Wow, I wasn't expecting to get a constitutional law question here.
Sorry.
That's a tough one. Well, it's a law passed by Congress. Congress has the authority to do that, obviously. And health information is something that would fall under the federal purview. So it's something that they can certainly enact in this particular consensus based upon the interstate commerce, I think would be the basis for that.
But if a physician is practicing only in one state and isn't accepting Medicare or Medicaid, would they still be subject to that?
Again, if you're using electronic health records, it's not limited to Medicaid or Medicare. You could be transferring health information for reimbursement over state lines if you have a health insurer that's located in another state. Again, HIPAA really came about because of the transfer of electronic information. If you weren't using, if you have a paper record and you weren't communicating electronically with an insurance company, then technically you wouldn't have been subject to the HIPAA regulations. And in its advocacy, many practitioners weren't. So that's something that, again, it's evolved, but that was really what HIPAA was all about when that came into place.
All right. My second question is a little more day-to-day relevant.
I hope so.
So should you set up the EHR so that when lab reports come back, patients can see it automatically? Because 99% of them will be routine, even if they're abnormal. But say a CBC, which every once in a while is going to show a patient, if they Google it, that they have leukemia or etc. So they see something on a Friday night with 100,000 white count, and the doctor doesn't see it. We don't see it right away. They're going to be like panic stricken all week. This would really be a dangerous scenario, but there's no way of predicting in advance. So either you block all lab results or you let all the ones go, and they're going to start seeing things, pathology reports for colonoscopy, some of which are going to be bad cancers, etc.
Right. Yeah, it's alarming, and it's I think they're trying to, but that's how I read it, is unless you have one of those exceptions where you can hold back the information, based upon the information blocking definition, if they request that information, they can access it as soon as it's available on your system. You can't hold it back.
So patients are going to become aware that they have cancer before the doctors are in many situations.
Unless there's a way to frame it that there's you can hold it back because of it would do harm to the patient. So perhaps something as heightened as you're saying, studies that would show cancer or something along those levels, you could have a policy in place. Before you do. So that may be an instance that falls within that exception.
So that would be the whole category. Like, for instance, if you do colonoscopies or skin biopsies, or where a certain percentage of them are a cancer that ultimately could be fatal, and you don't want the patient seeing that at 1 a.m. by themselves, you could block that whole group because.
Yeah, see that it's very complex, because then what I was saying before about it being non-discriminatory, that's one of the things they're looking to eliminate. They want to have consistency. So perhaps, like I said, just if based on your professional judgment, it reaches that level that any of these tests coming in from that study could be harmful if it's released to to a patient that falls within that category, then you could potentially have a policy in place that states that it must be reviewed before it's disseminated. But again, it's going to require some review of the statute and an implementation of a policy for sure.
We don't
Sure.
have control over that. The radiology reports are already being released to patients. The labs are already releasing them. It doesn't even come through us. Dave's right. They get it before we get it. So it's already happening. It's out of our control.
Yes.
I wanted to ask a question about emancipated minors or situations where they're emancipated. So, for instance, sexual activity, things like that. How do we handle those kind of issues?
Right. So that's one of those exceptions where it could fall into the harmful. Could harm a patient if it's released. So that's one exception right there. And then it also could raise an issue about the segmentation, depending on the capabilities of your EHR. So that would likely fall within something that is, well, even the privacy exception. If you have a minor that's receiving such treatment, an emancipated minor or an older child. So there's a number of exceptions where that could fall into where that information theoretically could be held back.
So you're
But how do you implement that
information on their frequently asked question? That's one of the points that I believe ONC was addressing.
So how do you implement that practically, right? So do you just not give parents access to the patient portal so that they can't access the records at all? Because if you're asking about sexual,
that segment of it may be something that could be held back. Again, that's probably something that has to be discussed with the IT or the EHR vendor. How do they put restrictions on that type of information?
But
so currently our HR vendor doesn't allow us to just block one specific section of the progress note. Okay. So, I mean, in terms of coming Monday that this is being implemented, should we just not release notes for pediatric patients if they're sexually active? Like what do we do starting Monday to deal with this?
Right.
Yeah. Well, like
how
I
would
said,
you advise
Yeah,
us?
because it flies right in contrast with the Teenagers' Bill of Rights and confidentiality.
Yes.
Starting at age 13 in New York State.
Right. I don't have a definitive answer for you on that. I could certainly look into that and get back to you, because again, this is a new world for everyone. So it's something that I would have to look into myself to get an answer to you, and I'll be happy to do that. I can provide that to Stephanie.
If a patient wants their records, you have to give it to them?
When you say wants their records, what are we talking about?
Their full record, if they want it sent to them.
Yes.
Okay.
that's the easy one. When the patient is making the request for access to everything, yes. And again, this is, I want to, the ONC requirements has to do with requests for access. So it does not require that all of this has to be available. It's when the request for access is made. So it's not a blanket situation where this all has to be in place for everyone. It really applies to when a request is made. So if the patient requests access to this information, or if or wants to use the information, that's really that's an important distinction that you need to be aware of.
How is that different operationally from the current New York State public health law where patients are entitled to their records?
Well, we're talking about two different things here. We're talking about the information blocking requirements apply to requests coming in. Anyone can make a request or get access to their health record, but this final rule applies to when there's a request for access. So it's not a situation where it's automatic, blanket in place. You have to have all these capabilities up and running for everyone. It's really pertaining to when a request comes in. That's sort of, request in the context of electronic health information access via, say, an application or a software.
Are doctors and other providers going to be able to use this act as a defense if they're sued? So, I mean, I could see thousands of possibilities. A woman comes in, gets a pregnancy test. She's previously given her husband authority to see her EHR online. He sees that she's pregnant and says, "Oh, wait, we haven't had sex in 2 months." All sorts of bizarre things are going to happen because of this law, which, I mean, I know you didn't write the law, but are physicians going to be able to use this as a defense and say, "Listen, I had no choice"?
Yeah, I mean, theoretically, it may have advantages to it. It also has, as technology, one important thing about all this technology is the metadata, showing who had access to it and when and what was looked at. I mean, it's a double-edged sword. I mean, you think about, now you have patients, it could be used as comparative negligence against them because, well, you saw this, didn't you? You were aware of this test result and you didn't do anything about it. Usually it's used against the doctor, I find, but this is, maybe, the greater access could be helpful in the long run.
I think we had a couple of questions in the chat. Someone had asked, what if you don't use EHR?
I'm sorry, Stephanie, you broke up.
Oh, sorry. Someone in the chat had asked a question. What if you don't use EHR?
Then you would not be subject to these regulations. Again, that's one of the elements in the requirement is the electronic health information. You're a user of that, and if you don't use EHR, then you're not going to fall within this category.
I have a question. I was under the impression the CARES Act was more that you're supposed to release all the records kind of automatically, so patients just have full access. They don't have to request like they used to. Am I mistaken about that?
Well, again, this is requests for, I mean, they have the access to it via, if you have a portal in place, things like that, but theoretically, the way this is written is request. So if a request from a provider to another provider comes in, or even a request from a patient, I want this information, I want my, again, there's a number of ways this information can be disseminated and accessed and by various individuals. So, it can get a little confusing when you think about it, because again, you're thinking about, especially with today's technology, I can go on the computer, I can get my information and, I'm requesting it because I'm going on and I'm accessing it because you have it in place. So yeah, that's one situation, but there's also other situations where a patient could call and say, okay, I want my information released to my attorney I want you to release everything to them. So that's a request, and I want you to release it to them, you know, in electronic format, and I want you to give them everything. You know, so there's a number of ways it can be requested and can be accessed.
I have another question. What about, you're saying for, sorry, you said psychological notes, or what was the specific language used? Psychotherapy notes. So if in the same note you're talking about your findings from a session with as you're the psychologist, but you're also talking about your management and plan for what you're going to do with the patient, and you can't separate out those two, where would that fall?
Again, if you're talking about, you know, psychotherapy notes are unique, you know, segment of a health record. We're not talking about, like, you know, a commentary about, like, mood or whatever, depressed. Psychotherapy notes are specific to someone who performs that type of treatment. If you are performing psychotherapy and you have psychotherapy notes, you would have to redact that information, or again, you would be encountering, you know, try and segment it, or if you can't segment it, provide it, I suppose, in an alternative manner, where it would have to be perhaps generated and redacted, where, you know, where those particular passages are removed, and then you provide the remainder of the chart.
What if you tape your sessions with the with the patient? Is that, the tapes have to be turned over?
I've never. You're recording the session with the patient, and I assume you're obtaining their consent to it, so they are aware of it. It's theoretically part of the medical record, so they would be entitled to that. As far as based upon my evaluation, it's part of the, it would become part of the medical record. Same as if you were a plastic surgeon and you took photographs before and after. That's all part of the health record. If you have recordings of your session, that would be something that they would be entitled to, I would believe.
Thank you.
Is anything a patient does with their records once they pull it off their responsibility? So I could see a patient printing out 20 pages, and of course it's not reading it, and they hand it to someone and says, you know, hurt left elbow while breaking into somebody's house last week.
Patients aren't subject to HIPAA regulations. Right. So, you know, they can, once they have it in their possession, it's theirs. They can really, it's not a situation where you're providing it to someone else who is subject to HIPAA that has to follow certain protocols and requirements. A patient doesn't. So once they have their protected health information in their possession, they can really do with it as they like, to their peril.
But when and to their peril, they can't turn around and say, well, I didn't know it was in there, because they should have read it, right? If they give it out.
Right. I mean, and once they have it, if they disseminated it, that's really would be on them. If there's something in there that's you know, harmful to them on a personal level, yeah, okay, that would be their issue.
Sure.
For sure. Okay.
Okay, that sounds like sound of silence may be that there's no more questions. So if not, we'll wrap it up. And thank you so much for speaking on this tonight for us. Hopefully everyone found it helpful and a lot of good questions. So I think we are good to go. If there are any other questions, feel free to email me at nisoms@nisoms.org, and we can always pass along the question if something comes up later. And I think that's that's where we'll end. So thank you so much. Thank you for speaking. Thank you to Milmick for helping to coordinate this for tonight. And thanks for everyone attending. We appreciate it, and stay well and let us know if you need anything. So.
Okay. Thank you, everyone. Have a good night.